Hello everyone, my name is Michelle Day. I'm going to talk about the case of Scott D. Clark CPA in December 10, 2021. So the purpose of this presentation is to observe the public feelings surrounding and relating to an individual CPA that has been sanctioned by the SEC or United States Board of Accountancy. Using public feelings, we are trying to get a better understanding as to why the person in question did what they did, so that we can avoid similar pitfalls as we start our careers in public accounting. Especially, I'm going to take CPA exams and going to um, get a CPA license. So this is so important for me to learn from the mistake from the people so I can avoid it. And again, topic I selected is Scott D. Clark CPA. You can see his photo. I got his photo from his LinkedIn profile. He was 61 years old, a task manager, task director, and vice president of corporate taxation for Cintas Corporation since 2000. He lives in Ohio and he got the CPA license in Ohio State, but not have a permit to engage in public practice. Some background about Scotty Clark before the incident. So he attended University of Cincinnati Bachelor of Business Administration in accounting major from 1978 to 1983. I couldn't find any information before he worked for Cintas Corporation. And I only know that he worked as Vice President Corporate Taxation for Cintas from 1991 to September 2020, according to his LinkedIn profile. Summary about the incident. This matter involves aiding and abetting and causing violation of the auditor independence rules arising from EY LLP, a public accounting firm performing non-audit services for its audit clients in Task Corporation on the contingent fee basis for task credit and incentive service performed between July 2009 and August 2018. An audit firm is not independent of its audit client if it provides any non-audit services to the audit client for a contingent fee. As a result, EY was not independent of Cintas during that period of time. Scott D. Clark, respondent, a certified public accountant, was Cintas vice president of corporate taxation at that time. Throughout the above time period, respondent approved on behalf of Cintas the payment of invoice for EY of C&I services calculated on a contingent fee basic about 10% every year. As a result of his conduct, respondent willfully aided and abetted and caused Cintas to violate Extreme Act Section 13A and Rules 13A-1 and 13A-13, which require the company to file annual and quarterly reports audited and reviewed by an independent public accountant. Moreover, respondent willfully aided and abetted and caused Cintas violation of the federal security laws within the meaning of the Section 4CA3 of the Exchange Act and Rule 102E1 Chip Y of the Commission Rules of Practice. So after reading the incident, I have some further thoughts that EY had to obtain pre-approved from Cintas Audit Committee under Section 10AH of the Exchange Act in order to provide non-audit task services to Cintas. Note that EY complied with the PCAOB Rules 3524, which requires written disclosure of a fee structure that complies with the auditor independence rules. And these policies and procedures, after presentation from EY, the engagement letter was signed by both management and audit committee relating to the billing the C&I services on a time and materials basis. Then Scott was aware of the audit committee presentation and signed engagement letter after reviewing. So the question is that they do not know the independent rules, not intentionally ignore it, or they think that people will never know about this. So according to the incident that Scott knew about the independent rules that EY shouldn't provide non-audited services to Cintas for contingent fee, but he still ignored it. He may think that the people will never know, but the truth is we know. So what laws were violated? Scott violated Section 4C and 21C of the SEC, a Security Exchange Act of 1934 and Rules 102E1 GY of the Commission Rules of Practice. So what is the Section 4C? That the Commission may censure any person or deny temporarily or permanently to any person the privilege of appearing and practicing before the Commission in any way if that person is found not number one is not to possess the requisites, the qualification to represent others. Number two is to be lacking in character or integrity or to have engaged in unethical or improper professional conduct. So Scott knew about the independent rules and EY violate the independent rules when they charge non-audit services with contingent fee, but Scott ignored about that, ignore it. And or number three, to have a willfully violated or willfully added or abetted the violation of any provision of the security laws, the rules, and regulation issued thereunder. How about rule 102? The Commission may censure a person or deny temporarily or permanently the privilege of appearance or practicing before it in any way to any person who is found by the Commission after notice and opportunity for him in matter to have a willfully violated or willfully added and abetted the violation of any provision of the federal security laws or rules and regulation thereunder. And then beside that, we can see, we come back to the summary, we can see beside the Section 4C and Rule 102, we can see that the Cintas violates 13-13A and Rules 13-A-1 and 13A-13. So what's the firm policy? The firm policy is that the high key positions such as manager, director, vice president, CEO, CFO, etc. have to be responsible for managing and giving the right decision for the company. So in this case, Scott was a task manager, task director, and vice president for corporate taxation. So he would respond for all the decision linked to the tax department, and he was the CPA too. So in this case, Scott knew about that EY violate the independent rules in contingent fee. So if he should do the right thing, he could tell the EY that, oh, EY violate the rules, so EY should charge the fee with a different method beside contingent fee, for example, hourly, anyway, not contingent fee, or Scott should not approve the invoice paying to the EY and not agree about that. So what was the punishment by the SEC? So within 14 days from the order, respondent pays a civil money penalty of $30,000 to the SEC. Respondent may transfer with different ways. For example, electronically or direct payment from the bank account or cash check. And moreover, respondent was denied the privilege of the appearance and practicing before commission as an accountant. For example, he cannot be a CEO, CFO, provide service as an auditor because he cannot sign the audit paper. After 1 year from this order, he may ask for reinstatement by submitting an application to the attention of the officer of the sheriff accountant. Respondent shall provide an explanation as a facts and circumstance to the matter. If commission has discovered contrary information or respondent is not able to provide the documentation and truthful and accurate attestation. And besides Scott, I also did some research and found that SEC ordered against 3 people from EY as following. So the first person is Philip Horak, an attorney and a former EY engagement manager who approved EY invoice sent to Cintas containing contingent fees for non-audit services for several years. Adam Bering, an attorney and the EY engagement partner for non-audit services, who failed to perform a reasonable inquiry in response to information that staff under his supervision were billing Cintas for non-audit services on a contingent fee and did not stop the practice. And the third person is Alan Greenwell, a licensed CPA and former EY partner who engaged in improper professional conduct within the SEC's rules of practice by failing to investigate red flags regarding the contingent fee arrangement. And after the incident, Scott is working as a manager for Kelly Clark Design, his wife's interior design service, after the incident to present. In 2020, he posted the announcement of retirement from Cintas Corporation. And then after that, he worked for his wife company until now. And the final is, I have some personal thoughts. So the SEC does not mess around, initially showing as pretty an SEC should against relating to people so that people can learn from this case. So they seriously use the law in their practice, especially when they are CPA. However, this case gives me a second thought. Scott may not know about serious consequence of the independent rules when violating this rule. He may take things more seriously if he had been an auditor or worked in a public accounting firm. Thank you for listening.